Reflections and jurisprudential information on legal news and legislative provisions during the COVID-19 period. Revival Decree. The government has created a new law calling it the Revival Decree number 34 of 19th of May 2020, which, as part of an articulated framework of rules of various nature, contains numerous interventions of revision and integration of labour law, provisions of the previous Cura Italia decree. The following topics have been defined. Redundancies. The ban is prolonged until 17th of August 2020. Social security. A maximum number of weeks duration of special social support payments planned to deal with an economic emergency. CIGO, FIS and CIGD Cassa in Deroga for employers in the period between 23rd of February and August 31st, 2020. Furthermore, in the following period between 1st of September 2020 and the 31st of October 2020, it's possible the use of a further 4 weeks without prejudice to the spending limits provided for in the refinancing regulation. However, only for employees in the sectors of tourism, exhibitions, conventions, show business, charity, recipients of ordinary allowances, FIS. This includes the period preceding the 1st of September. Leave for working parents is doubled from 15 to 30 days, continuous or split period, usable until July the 31st, 2020. As an alternative to paid leave, it remains possible for workers to ask for one or more bonuses for the services of babysitting. The maximum amount is from €600 to €1,200. The permit's 104 increase by an additional 12 usable days, even continuously in the months of May and June 2020. It is a total of 12 days, not of 12 per month. Damiana Lesce e Tommaso Targa, lawyers at Trifiro and Partners. Liquidity Decree. The Liquidity Decree envisaged two main forms of guarantee for business financing, one with recourse to SACE and one to Fondo PMI. It must, however, be highlighted that for the purpose of granting the guarantee and the consequent financing, the status of the company is noted on a specific date. In fact, if the company is already in a situation of probable crisis, then request for new finance on the one hand and its concession on the other could create problems of responsibility for both the bank, financier and for directors of the financed company. SACE's credit as a public entity's credit could be qualified as preferential credit. It is evident that recourse to COVID-19 liquidity occurs in such a way that the company's state and corporate continuity is taken into account. This is because the bank's evaluation dispenser is based on a 2019 situation, probably not yet certified by an approved budget. These measures are aimed at monitoring the situation precisely and objectively to help the entrepreneur to verify compliance with the rules, as well the effectiveness of certain choices and the correctness of expected returns based on the characteristics of the company and the market in which it operates. Vittorio Provera, lawyer at Trifiro and Partners, and Dr. Franco Rabiti of Rabiti and Partners.